May it please the Court, my name is Bill McCabe. I represent the claimant, Nellie Quavato. I'd like to reserve 2 minutes for rebuttal.
I'll try to remind you.
In this case, the Judge of Compensation Claims denied claimant's request for attendant care from August 10, 2004 to September 7, 2004 on the grounds that Dr. Agol's prescription for attendant care was retroactively made. We submit this as error. The judge first found that even though claimant's accident occurred on January 25, 2003, the applicable statute for awarding attendant care was a statute in effect at the time of the attendant care.
Well, Mr. McCabe, isn't that exactly what our case law says is the determinative period for attendant care?
Well, that
Castro and Socolow?
That gets to my second point, and yes, there's numerous cases that say that, but I backtrack it in my brief. It starts out, I mean, the basic law is if a statute is a procedural change, then it applies retroactively. If it's a substantive change, it does not. The first case where this Court started holding that the attendant care statute that applied was a statute in effect at the time of the service was that Williams versus Amax case, and it was a procedural change. The Court was very clear to state that there were procedural changes, and it's kind of bootstrapped from that case forward to where it appears to be almost like just a matter of law now. However, there was one decision, it's Diana versus HLS, it was a 1996 case, that held that an amendment to the attendant care statute was substantive. It was a 1990 amendment, and therefore that did not apply retroactively.
What was that change?
That basically changed the definition of attendant care.
Okay, but then isn't that a basic difference here, where that is a definition of attendant care and changes a right to the care, where here it's just a matter of the procedure you follow to get the attendant care. There's no change in the substance of the care, is there?
Well, we submit, I mean, there's no change in the actual substance of the care, but we submit that if the statute is interpreted in the manner that the judge interpreted it below, that is, that there's a hard and fast rule that retroactive attendant care is not allowed, irregardless of the fact that the employer carrier does no investigation whatsoever, then it's a substantive change. And the reason that I argue that is because prior to the October 1st, 2003 amendment, this Court, first of all, did allow retroactive attendant care. Secondly, there's a string of cases that hold that an employer carrier has an obligation and a duty to investigate and to timely give a claimant needed benefits. In fact, that's actually codified in 440.015. The system's supposed to be interpreted for quick and efficient delivery to injured workers. It's supposed to be self-executing, et cetera, et cetera. Our argument is that the 2003 amendment to the attendant care statute, which says you can't have retroactive attendant care, doesn't alter the employer carrier's obligation to undertake an investigation and still place needed benefits in the hands of an injured worker.
But wouldn't that just be saying that that statute trumps the other statute, which is specific? And aren't you asking us to apply the general when you have a specific statute on this question?
Well, what I'm asking is, it seems that the 2003 amendment to the attendant care statute, that if the employer carrier undertakes a reasonable investigation to determine whether or not attendant care is appropriate, then yes, retroactive attendant care shouldn't be allowed. But if the employer carrier undertakes no investigation, if they completely abscond their duties, it really amounts to an estoppel type of argument, but if they...
But couldn't you make the same type of argument on statute of limitations and other things, Mr. McCabe? Well, just say that the claimant is absolved from all responsibility under specific statutes in 440 and go forward?
Well, it actually has been used for statute of limitations, and, you know, if an employer carrier does not...
There's some estoppel, I know, but you're saying they got to affirmatively go out and do what appears that the claimant's attorney should have ensured was done here.
Well, see, there's a years of case law that say that, Your Honor, and the statute is an employer carrier monitored statute. It's not a claimant monitored statute. It's not a doctor monitored statute. Now, the way this statute is written, or the way the judge interpreted it, it's now become a claimant monitored system.
Yeah, I see where you're coming from there. I mean, I understand that You were arguing that the carrier had a duty. Isn't it just that in this particular circumstance, we're changing the procedure, that the employee has to seek or, get the diagnosis beforehand, the written authorization beforehand?
Well, our position is it's really not just changing the procedure, Your Honor. It's completely changing the duties and responsibilities of the employer carrier. It no longer requires them to investigate, to place needed benefits in the hands of an injured worker. They now, in fact, actually, they'd be crazy to investigate now. What would an unrepresented claimant do? Unrepresented claimant would have no idea.
Mr. McCabe, in your argument with the legislature on that, that point has been specifically addressed, specifically made binding on the system across the street.
Well, I think the issue is, does the amendment to the attendant care statute eliminate an employer carrier's obligation to, which has been through the entire workers' compensation scheme?
Okay, and your argument is that's a substantive right of the claimant to have the employer conduct this investigation.
They don't have, if the employer carrier doesn't have to investigate anymore, if they can now hide behind a willful wall of ignorance, et cetera, doesn't that change their duties and responsibilities under the Act? Isn't that a substantive change?
Well, wouldn't they have to still put in that little booklet they're supposed to give people and knowledge and so forth to try to educate? Isn't that part of their duty and obligation there to advise the claimant of their rights and so forth? And wouldn't this be a part of that advisory requirement?
Well, it is part of their duties to advise a claimant and so forth, and if they don't, then they're stopped basically from relying on the statute of limitations. It seems like the employer carrier's duties and responsibilities and the statute can be very easily harmonized. If the employer carrier does their job of a reasonable investigation, which they easily could have done in this case, by the way.
3 minutes.
Thank you, Your Honor. In this case, they sent a nurse to talk to the doctor. All they wanted the nurse to ask the doctor was, is the surgery related to the accident? She said if they'd asked me to ask about attendant care, I would have asked them. The doctor said if anybody had asked me at any time whether the claimant needed attendant care, I would have said yes.
Well, Mr. McCabe, what you're saying is that whether we apply the statute or not prohibiting retroactivity would then become a question of fact to be applied in each particular case according to the facts and circumstances.
Well, what I'm saying is if the court interprets it as a matter of law that no retroactive attendant care is allowed no matter what, whether the employer/carrier does nothing as they did in this case, then our argument is that the statute is a substantive change in the law because it completely alters the employer carrier's duties that have been their requirement and obligation almost throughout the entire workers' compensation system. And if it alters their duties that much, then that flips us back to the statute in effect as of the date of this lady's accident, which would entitle her to these retroactive benefits.
Are you saying the changes are substantive rather than procedural when they prohibited retroactivity?
If it's interpreted to prohibit retroactivity across the board, even if the employer/carrier does not do their duty to investigate.
Yeah, let's get that out off the table. But let's just assume that we don't buy your argument there. What's your fallback position?
Well, if you don't buy my argument there, then...
I'm not saying we won't, but I'm just saying let's assume it for the purpose of getting to the point for me today.
Well, that's my argument, Your Honor, is if I don't have a fallback position...
That's your story and you're sticking with it. Is that what we're...
Yes, sir.
All right.
Thank you.
May it please the Court. My name is Terry Bussey. I represent the appellees in this case, the employer carrier, Laro Services, and the servicing agent, GAB Robbins. The issues that we're here today, the main issue that it revolves around is whether the 2004 statute, which was amended in 2003, applies to the attendant care that the claimant was claiming in the underlying case. The judge denied the benefits, found that the 2004 statute did apply, that the prescription for attendant care was retroactive.
Well, let's take Mr. McCabe's argument head on.
Okay.
His argument is that a claimant had a substantive right to have the carrier make an investigation and provide the benefits. And I'm not asking you to say it wasn't done here, but just take on that argument in the abstract,
Okay.
that's a substantive right. Why isn't it?
Well, Your Honor, I disagree. I don't think that's a substantive argument. I think in the cases that were cited in regard to the employer carrier's obligation to investigate, those were fact specific. Each one of those cases, in that particular case, the claimant was in a back brace or in a wheelchair. In this case, for one thing, there was no evidence admitted into trial that in this particular case, that the employer carrier had a duty to investigate on this case and failed to do so. The judge made no finding of that. So we would argue that that is not a substantive change to the statute or substantive requirement. The Florida legislature amended that section to require additional procedures. That, in fact, the opposing counsel also admitted on your question on direct that there was no change in the substantive right to attendant care benefit under the 2003 amendments that were applied to the 2004 statute. If that be the case, then the 2004 statute applies here. In this case, there was no evidence. Dr. Gall, in fact, testified in answer to your question as well that in terms of wound care, all she needed was to remove her dressing and keep it dry. Nothing in that statement should have put the employer carrier on notice that they needed to investigate that she needed attendant care. In fact, in his deposition...
But, counsel, this was low back surgery. That sort of goes without saying that you're going to need somebody to help someone that's been through a low back surgery, isn't it?
I disagree, Your Honor. In fact, there were no questions asked of the doctor. There were no questions even asked of the nurse case manager. In this case, would it have been necessary for there to be attendant care? Was that something that should have been asked? There was nothing to say that every single back surgery requires attendant care. There's no evidence to that effect. In fact, Dr. Gall, in his submission to the carrier for authorization for the surgery, on the form it had a spot on there where they could have requested authorization for attendant care, and it was left blank. The doctor did not ask for that. There was an opportunity to do that, and he didn't do so. That obviously would not have put the carrier on notice that they needed to inquire further. There was nothing indicated about attendant care. The claimant also argues that there is ambiguity to the statute. The employer carrier disagrees. The statute is clear. In Lee County Electric Co-op versus Jacobs, it was a Florida Supreme Court case in 2002, says when the statute is clear and unambiguous, courts will not look behind the statute's plain language for legislative intent or resort to statutory construction to determine that intent. The statute clearly says, that was amended in 2003, that applies to this case, that there shall be no retroactive prescription of attendant care. It doesn't say there shall be no retroactive prescription of attendant care if the employer carrier fails to investigate. If the Florida legislature had intended to say that, they would have said that, and they did not. Additionally, the duty to...
So in effect, there's no way to enforce the employer carrier's obligation to investigate.
I disagree with that, Your Honor. I mean, I don't think that's even an issue in this particular case. There was nothing proven that they had a duty to investigate in this case. I can't answer for other cases down the line that may be coming up, and I think there are some. But in this particular case, there was no evidence that they had a duty to investigate in regard to this particular surgery.
I mean, I've got a little trouble with your saying that someone applying common sense when looking at someone who has had back surgery would just to say, oh, well, they can just reach back there and change the dressings themselves. I would submit that most people who have had back surgery have had a very difficult time cleaning and changing the dressing unless they've got incredibly flexible abilities and a very good mirror.
Well, actually, Your Honor, if you look at Dr. Gall's testimony, she didn't have to change the dressing. All she had to do was take it off. His testimony that's in the record merely states for wound care, what did she need? He said nothing but to remove it after 48 hours. That was it. So there were no dressing changes.
I'm going to go back. You kind of went to the facts of this case, and I'm trying to stay away from the facts of this particular case, just to find out whether this is procedural or substantive. I mean, Mr. McCabe's argument is that there is a substantive right to have the carrier investigate and provide services. Why isn't that on a substantive right that is at least impinged by this amendment?
Well, Your Honor, the right that he's talking about is not statutory. That was an interpretation by the courts. He's referring to, the only reference that was made was to Section 440.015 in the Florida statutes, which is the legislative intent section. That section does not state that the employer or carrier will investigate each and every.
Would you agree the case law prior to that statutory amendment did in fact hold that?
Yes, Your Honor, I do agree. I agree that this court has held in the past that the employer carrier in those cases had a duty to investigate, but I don't believe that that is across the board. I believe that's a case-by-case analysis, because if that be the case, where does it stop? Does the employer carrier, the legislative intent in 440.015 also says that the system should be efficient, self-executing, and not overly burdensome. If the court's position would be that that's a substantive change and that the employer carrier has a duty to investigate every single medical procedure as to whether they need attendant care, I think that would be overly burdensome. So I don't believe that that's necessarily a substantive right. And, Your Honor, basically, I think it's been pretty clear on that. I think that the court should affirm the judge's ruling of denial of the benefits. This court has found in numerous cases that the appropriate statute to apply to attendant care is the statute in effect on the date that the attendant care was provided. Counsel has even agreed that these changes to 2004 were not substantive. They were procedural or remedial. Therefore, we would request that the court affirm the judge's ruling, if there's no other questions.
Thank you.
I just have to respond to the contention that it's fact-specific cases that impose the obligation on the employer carrier to investigate and provide appropriate benefits. It's the cases I cited are attendant care cases, but there's other cases like some of the old bad faith attorney fee cases had the same thing. It's supposed to be a self-executing system. In this particular case, how hard would it have been to have the nurse that actually went to the doctor's office to see if the back surgery was related to the accident just ask, is attendant care appropriate? And I'd just like to point out from Smith versus DRW Realty Services, 569 Southern 2nd, it's a 1990 case, but it says that the employer must offer benefits when the employer knows or reasonably should know such benefits are due. It says this language does not admit of the interpretation urged by the employer carrier that telling the claimant to make the judgment regarding his need for care fulfills its obligation. We've now transferred the system from employer carrier monitor to doctor or claimant monitor. That's what it amounts to, and I don't think that's what the legislature intended by 440.15 and the years of case law that's preceded this case. Thank you.
Thank you. Seeing no further